All right, everyone, it's now 2 p.m. We're going to get ready to get started. This is the State Expedited Accusations calendar. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All participants, as you've just been made aware via this Zoom conference, this proceeding is being recorded. It's also being broadcast as a live stream over the internet. That means any member of the public can log on and watch. All defendants, you have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today. Those who receive a signature bond today will be reset further notice to a division judge, and those who receive a surety or a cash bond today will be reset to the August 8th calendar. All right, who do we have first?
That should be September the 8th.
I'm sorry, I apologize. It'll be reset to September the 8th of 2022. That makes more sense. All right, thank you. Are there any announcements at the jail regarding medical resets first before we begin?
No, we do not have that, Judge.
All right, perfect. Thank you. Have all public defenders had the opportunity to interview their clients?
Yes, Your Honor, Deborah Melnick for Public Defender's Office. However, position number one, Carlos Gonzalez, he is needs an interpreter, and I have not had a chance to speak with him. I have spoken with everyone else.
Mr. Jordan, will we be able to have an interpreter today? Do you believe?
She just logged on, Judge.
Oh, wonderful. Okay. Ms. Melnick, do you have the whole calendar today?
No, Your Honor, I have positions 1 through 6.
Oh, that's perfect. Okay. If we could take the second half of the calendar.
Yes, Your
Also-
Honor, that'll be me, Attorney Jasmine Moses Counts with the Fulton County Public Defender's Office.
All right. Good to see you, Ms. Moses Counts. If Ms. Melnick could go, where is position 1, Mr. Gonzalez? Is he at courtroom 2 or 3?
Yes, Judge, we're getting ready to have him do the breakout in courtroom 3. We're sending him over there now.
Perfect, thank you. So when he arrives there, can Ms. Melnick be put in a breakout with courtroom 3? And can we start with a position that Ms. Moses Counts has?
Judge, I'm sorry, I apologize. Francois, who is that sitting in the chair? We need to do that position first, please.
Yes,
The
thank
possible
you.
judge.
This is
Thank
position
you.
4, Mr. Goodwin. Thank you.
All right, Mr. Goodwin, your case 22 CR 005722Y, in which you're charged with 1 count of criminal trespass with the offense date of August the 25th. Do you understand your constitutional rights? Does he understand?
Go ahead.
You understand your rights?
Yes.
Thank you. All right. Ms. Harrison, good to see you. What's the, can I have the history, please?
Good afternoon, Judge. 39 cycles with history in Georgia, Florida, Alabama, and Tennessee. Last arrest, December of 2021 for theft by shoplifting in Fulton County. No disposition listed of that arrest. Record does indicate the defendant has an open case in bench warrant, dormant bench warrant status 21 CR 006106Y for criminal trespass and obstruction of law enforcement officer. Record indicates 5 violations of probation, 3 failure to appear within the past 10 years, a 2019 felony conviction for entering auto and financial transaction card fraud, 2 counts. 2016 aggravated stalking and a battery misdemeanor conviction in Carroll County, Georgia. A 2017 misdemeanor conviction for giving false name. Nothing further to add.
All right, thank you. Is this your case, Mr. Borger?
This is, Your Honor. Thank you.
It's good to see you. What is the state's recommendation?
Thank you, Your Honor. The bond's currently set at $500 surety. State's just asking to keep it at $500 surety, along with the stay away from 1715 Howell Mill Road. That's a Kroger. And no guns, drugs, and alcohol while on bond. That review of the defendant's arrests, that's true, but he also has 19 cycles out of Tennessee. So we're seeing FTAs, we're seeing open bench warrant, multiple probation violations. I'm assuming that this defendant's also residentially challenged. So I know that a 500 surety for a criminal trespass, that's a little I guess not the norm. I know that signature bonds are usually issued for these types of offenses. But looking at the defendant's histories, ties out of the state, like I said, probably doesn't have a home or a stable home, at least, violent history. It's just unfair to these businesses to let these criminal trespassers right back out. So I mean, given the open bench warrant status, we do think that a $500 surety, which is very low, is appropriate for this case.
Thank you. Ms. Melnick?
Yes, Your Honor. The defendant actually does have an address. He resides at 610 Piedmont Avenue Northeast in Atlanta. The defendant does work with DCO Carpets. He installs carpets. This is where he refused to leave a Kroger. We are asking for a surety bond on this case for it to remain at $500 surety bond.
All right, based on the information before me, the bond will remain as set at the 500 surety, and he must stay away from the Kroger located on Howell Mill, and he is to have no alcohol, drugs, or weapons. All right, is there anything further from either the state or the defense?
Yes.
There's something further, sir? Please don't say anything. You have a right to remain silent. Please don't affect Ms. Melnick's ability to represent you, okay?
Okay. One bond is at 500.
Yes,
Somebody has to make a bond.
yes. If you have questions, please call Ms. Melnick, okay?
I can't get a signature bond.
I'm not gonna change my decision, all right?
No, sir.
All right,
Everything y'all need.
all right. Please call Ms. Melnick. All right.
Good afternoon, Your Honor. I'm sorry to interrupt. I'm the Spanish interpreter for position number 1.
Yes, good to see you. I'm waiting for you to get into a breakout with Ms. Melnick. Can we set up that breakout and then go to the end of the calendar?
Yes.
Who is
Judge.
at courtroom 3?
Position number 1.
Oh, good, great. Can we, Mr. Brown, will you put them in the breakout and we go to another position at courtroom 2? Is courtroom 2 still on the line?
Yes, I'm sorry, Judge. We had a little situation.
I understand, I understand. Is it okay now?
Yes, we're good.
Okay,
Next, we have position number, are they still doing the breakout?
yes, so we need to go to the end of the calendar if possible.
Position 7 on through is who I represent, Your
Come
Honor.
on, Mr. White.
All right, good afternoon, Mr. White. Your case number is 22 CR 005731G, in which you're charged with 1 count of battery, actually 2 counts of battery family violence, with the offense date of August the 26th. Do you understand your rights?
Yes.
All right, Ms. Harrison?
If he has no prior history, he does meet the criteria for UJR pretrial, nothing further.
Thank you so much. All right. Ms. Francis, good to see you.
You're still on mute.
Thank you. Good afternoon, Judge. I'm sorry.
All right, good afternoon.
This is a dispute between a boyfriend and girlfriend based on the warrant information. Judge, this defendant struck the victim while she was visiting her mother in the hospital. The incident took place in the bathroom at first, where the defendant held the victim around her neck. She was able to push him off of her and break free. And while she was in the presence of her mother in the room, this defendant punched her in the face. The officers did observe blood on the floor of the hospital. I believe that the victim told the officer that he also dragged her earring from her ear, causing her ear to bleed. The officers did observe dried up blood on her hair, and the victim did admit to the officer that she slapped the defendant, but that it was in defense of herself. The state is recommending $2,500 on each count of the battery family violence for a total of $5,000 surety bond. No further contact with the victim. Miss Angel Rogers, that's Angel normal spelling, Rogers, RODGERS, a family violence intervention program. Stay away from her home and work address. I don't have that address, Judge, but I'm sure the defendant probably knows what it is. And no drugs, alcohol, or weapons while on bond. Your Honor, even though this is the defendant's first cycle, the fact that the crime occurred in a public place where service was being offered and also in the presence of her parent, the state does believe that it's likely that the defendant will reoffend. And we're also concerned for the victims, for safety of the victim. So for these reasons, we're asking for the stated bond.
Thank you, Ms. Francis. Ms. Moses Counts?
Yes, Your Honor. Good morning or afternoon, rather. My client is Mr. White. He is 24 years old. He has a good address. He resides in Woodstock, Georgia. He is employed. He works at American Disposal Services and has had that employment for the last 3 years as a driver. He makes good income. I have informed him that after today, should he desire to have an attorney to represent him, he would not qualify for the services of the public defender. He has no other mental or physical health concerns, Your Honor. After speaking with him, as stated, he does have no history. So the state's contention that he would reoffend, to me, lacks fact or logic attached to that, Your Honor. These are alleged allegations that he's being accused of, and so he is going to move forward with disputing these charges. And so I would ask, based on the fact that he has no history, he's 24 years old, great employment, and has significant ties to the state. He's been here for the last 18 years. I would ask for your consideration for a signature bond.
All right, thank you. At this time, the defendant is going to receive a $5,000 signature bond through pretrial services. He is to have no further contact with the alleged victim, last name Rogers, and he must stay away from both her work and home addresses. He is to have no alcohol, drugs, or weapons as a condition of that signature bond through pretrial, and he is also to complete the one-day anger awareness course. Is there anything further from either party? All right, best of luck to you, Mr. White. Who do we have next?
Thank you, Judge.
7, Petty.
All right, good afternoon. Your case number is 22 CR 005729B, and once you're charged with 1 count of simple battery with the offense date of August the 26th. Do you understand your constitutional rights? Was that a yes? You understand your rights?
Oh, yes.
All right, thank you. Ms. Harrison?
Third arrest. Last arrest was May of 2016 for driving while license suspended or revoked in Henry County. That was a NOLO conviction. She is recommended for UJR pretrial, nothing further.
Thank you, Ms. Harrison. Ms. Francis?
Yes, Judge. In this incident, the defendant threw glass objects at the victim that struck him multiple times. She did admit to officers that she did throw the items at the victim, but that she was not aware that they had struck him. Judge, the state is recommending that the $2,500 surety bond that's in place remain as is. Anger management class, no further contact with the victim. Jaylen Ransom, that's Jaylen, last name Ransom with an E at the end. Stay away from 1947 Pine Oak Drive, and no drugs, alcohol, or weapons while on bond. Judge, this defendant does have previous battery in her history, but the state will defer to the court on this one since the site is limited.
All right, thank you. Ms. Moses Counts?
Yes, Your Honor. Miss Petty is 28 years old. She has a good address. She resides in Lithonia, Georgia. She is employed. She works at Home Chef as a production worker, and she's had that employment for the last 6 months, also making good income and would not qualify for the public defender after today. Your Honor, this is a matter involving my client and the father of her child. They have a custody arrangement, and this incident occurred when my client was attempting to pick up her child and was prevented from doing so in violation of the custody agreement. There is no fact within the police report that this glass cup was thrown multiple times, as the state has said. The fact and as written in the report is that the cup was thrown once, and that my client was physically touched before the cup was thrown. And so I would ask, based on the fact that she does not have a violent history of any notation of any convictions of any violence, she does have a good employment, and does need to get back to her child, I would ask for your consideration for a signature bond.
All right. At this time, Ms. Petty will receive a $4,000 signature bond through pretrial services. She's to take the one-day anger awareness course and to have no further contact with the alleged victim, last name Ransom. At this time, she can arrange transport of her child with a third party. She is to also stay away from the address on Pine Oak Drive and have no weapons, drugs, or alcohol as a condition. Is there anything further from either the state or the defense? Raise your hand.
No, Your Honor, thank you.
All right. Best of luck to you, Ms. Petty. Who do we have next?
Next is Damian Clay. Oh, come on, Mr. Clay.
That's gonna be Miss Melnick's client, Your Honor.
Okay, we can't do him next.
Yes,
Oh,
Your Honor, I'm back.
Ms. Melnick is back.
We
Ms.
can
Melnick
do
is-
that.
Ms. Melnick is back. All right, good afternoon, Mr. Clay. Your case number is 22 CR 005733J, in which you're charged with one count of battery family violence with the offense date of October the 12th of 2021. Do you understand your constitutional rights? All right, thank you, Ms. Harrison.
7 Cycles, last arrest, April of 2007 for burglary in the first degree. That was a felony conviction. Record indicates the defendant is currently on probation in Fulton County for aggravated assault, case 16 SC 145559. Sentenced February of 2017, 5 years confinement and 5 years probation. Record also indicates an additional open probation for burglary in the first degree, 17 SC 149839. Sentenced April of 2017 with 6 years probation. Record indicates 2 violations of probation within the past 10 years, 2015, 2 separate burglary in the first degree conviction. Nothing further to add.
All right, thank you, Mr. Borger.
Thank you, Your Honor. I just want to get refreshed. What position is this?
Position 3, Mr. Damian Clay.
Okay, great. Thank you, Your Honor. The state's asking for a $5,000 surety bond with the conditions of no further contact with Kenesha Clay. That's spelled KENNESHIA, Clay, CLAY. That's the defendant's sister. Stay away from 5856 Village Loop. That's in Fairburn. Enrollment in our anger awareness class and no guns, drugs, and alcohol while on bond. Your Honor, in this case, the defendant hit his sister, Kenesha Clay, several times in the face with a closed fist. The defendant fled the scene and was unable to be located up until now. So we've already heard that this defendant had a felony armed robbery arrest. Clearly, he owns weapons. Now he's doing violent crimes against his family. This is a pretty big threat for witness intimidation and just for the safety of Ms. Clay going forward, especially being a family member. It's often hard for family members to escape one another. So we do think that a $5,000 surety bond with those additional conditions would be appropriate in this scenario. Thank you.
Thank you, Ms. Melnick.
Yes, Your Honor. The victim in this case is Mr. Clay's sister. She is the 4th oldest. He is the 3rd oldest. This was a sibling dispute. He has a job with the temp agency, and he's starting a job with Google in Fairburn, Georgia, working in the warehousing. He works at warehousing. Is making $22 an hour. He is able, if released, and we are asking for $1,000 signature bond. If he is released, we are he can go and live with his mom, Yolanda Clay, YOULANDA Clay, at 770-837-8030, and that address is 4735 Courtney Drive, apartment J3 in Forest Park, Georgia. Again, this is a sibling dispute. This is not intimate partners, and we are asking for $1,000 signature bond.
All right, thank you. At this time, Mr. Clay is going to receive a $3,500 surety bond. He is to have no further contact with the alleged victim, last name Clay in this case, and he must stay away from the address on Village Loop. He can return one time with a member of law enforcement to get any items he may have had there, and he is to have no weapons, drugs, or alcohol. I see you raising your hand, Mr. Clay, but you have a right to remain silent. I don't want you to infringe on your constitutional rights. The best thing for you to do is to speak with Ms. Melnick. If you have a very brief question regarding the bond only, I can hear that. What is your question, Mr. Clay?
I just want, how could I stay away from my blood sister? It's been going on since childhood.
Okay. Well, at this time, you're gonna have to stay away from her. You're not to have any contact with her, all right? That's the ruling at this time. All right, if you have other questions, please speak to Ms. Melnick. She'll explain to you, okay?
Sit over
And
here.
best of luck to you.
Position 9, Russell. Oh, I'm sorry, Judge.
Position number 1, the interpreter case, please.
All right, we're gonna do the interpreter case. Before I begin, Madam Interpreter, will you please state your name for the record?
Lucia Urtuzastegui, that's URTUSASTEGUI.
And say it for me one more time, I'm sorry. Pronounce
It's
it for me.
Lucia Urtuzastegui, but you may call me Lucia, Your Honor.
All right, Ms. Lucia, will you please raise your right hand? Do you swear and affirm that the translation you will do today from English to Spanish, Spanish to English will be done to the best of your knowledge, skill, and ability, and as accurately as possible?
I do.
Thank you. All right.
Your Honor, if I may,
Yes.
After speaking with the defendant, with the interpreter's help, we are going to ask to have this case reset to the competency hearing on Thursday, and we are requesting that a Spanish interpreter be ordered to assist us.
All right, I still have to set a bond today,
Yes,
Ms.
Your Honor.
Melnick, so.
Yes, Your Honor, sorry. I was doing it.
But what we would do instead of SAP, we'll ask if it can be placed on a competency instead, all right?
Yes, Your Honor.
All right, good afternoon, Mr. Gonzalez. Your case number is 22 CR 00572-1Y.
Buenas tardes, señor González. El número de su caso es el 22 CR 005721Y.
I'm Judge Melanie Williams.
Yo soy la juez Melanie Williams.
In the case I just listed, you're charged with 1 count of loitering and prowling and 1 count of criminal trespass.
Y el caso que usted le acabo de decir es un cargo de vagabundear y un cargo de traspaso.
You have an absolute right to remain silent. Anything you say can and will be used against you.
Usted tiene el derecho de permanecer en silencio y cualquier cosa que usted diga puede y será usada en contra suya.
You have a right to an attorney, and Ms. Deborah Melnick is present and available to assist you today.
Usted tiene el derecho a tener un abogado y la señora Deborah Melnick es una abogada defensora y ella está presente y ella está aquí para asistirlo a usted.
This proceeding is broadcast over the internet. It's also being recorded. That means any member of the public can watch this.
Este proceso está en las redes y está de forma virtual. Eso quiere decir que cualquier miembro del público puede ver y escuchar esto.
You understand your rights?
¿Entiende usted sus derechos?
All right, we'll proceed. Assuming that he does. Ms. Harrison?
Your Honor, 2 cycles, last arrest, April of 2013, failure to appear. Underlying charge is criminal trespass, no disposition listed in that arrest. He does meet the criteria for UJR pretrial.
Y la juez,
Yes,
la
please
juez,
transfer.
la juez pidió la información sobre sus antecedentes. Existen 2 ciclos, 2 arrestos. El último fue en abril del 2020 por traspaso. Go ahead, Your Honor.
All right, thank you. Mr. Borger?
Thank you, Your Honor. The state's asking for a $1,500 surety bond.
Okay.
La fiscalía está pidiendo que se le dé una fianza asegurada por $1,500.
1,000 was issued for the loiter previously.
1,000 de eso fue por el cargo anterior de vagabundear
And $500 for the criminal trespass that was added on.
y $500 por el traspaso criminal, el cual fue añadido.
We'd also like the conditions of no further contact with Brian Smith and Janice Ricks.
También queremos la condición de no contacto, ningún contacto en el futuro con Brian Smith o Janice Rex.
Stay away from 700 River Bluff Parkway, that's in Roswell, Georgia.
Que permanezca lejos y no se acerque de la dirección de 700 River Bluff en Roswell, Georgia.
No guns, drugs, and alcohol while on bond.
No armas, drogas o alcohol mientras esté fuera en bono de fianza.
Your Honor, in this case, the victims were woken up by their dogs barking and looked outside and observed the defendant ransacking their yard.
Su señoría, en este caso, las víctimas fueron despertadas por los ladridos de sus perros y encontraron o vieron al acusado que estaba buscando y husmeando en el patio, en el jardín de ellos.
The victim's car doors were open with its contents thrown to the ground.
Las puertas de los carros de las víctimas estuvieron abiertas. Todos los contenidos de eso estuvieron tirados por el piso.
Patio furniture was strewn. A hot tub cover was removed.
Las muebles del patio estuvieron desordenados, tirados. Fue quitada la tapa de la tina de agua caliente.
The defendant was apprehended. Nothing was stolen, but the victims were scared.
Nada fue robado. El acusado fue detenido. Nada fue tomado, pero las víctimas tuvieron miedo.
Nothing further from the state.
Y eso es todo lo que la fiscalía presenta.
All right, Ms. Melnick.
Yes, Your Honor. The purpose of today's hearing is to determine bond. This is not a trial. I don't know if you want to interpret for me.
Sí, señoría. El propósito del día de hoy de esta audiencia es para determinar el bono de fianza, no para determinar juicio.
However, the defendant was merely found in a remote proximity of this apartment complex. There are no eyewitnesses nor cameras.
El acusado fue encontrado en la proximidad de esta dirección. No habían cámaras, no habían testigos que lo hayan visto.
The defendant, I did not hear where he has any prior convictions.
No escuché nada de que el acusado tenga ninguna convicción, o sea, que lo hayan encontrado culpable anteriormente.
He's 44 years of age and he meets the criteria for unsecured judicial release.
Él tiene 44 años de edad y concuerda con el criterio para que lo dejen salir por la juez.
The defense is asking for the court to issue a UJR on both counts, or in the alternative, we're asking for $500 signature bond on each count.
Y el abogado defensor está pidiendo para que en cada acusación le den un BJR o alternativamente un bono con firma nada más de $500 por cada una de las acusaciones.
In Your Honor, he has no convictions because he failed to appear.
Wait, before you speak, Ms. Berger, to clarify, Ms. Melnick, you're no longer requesting the reset that you asked for at the beginning, and you're changing your position to signature bond?
Yes, Your Honor. We are asking for a signature bond, and we can because I do not want him to remain in custody.
Very quickly, can I go into a breakout, please?
Yes, Your Honor.
With Ms. Melnick and Mr. Borger
Yes.
and any supervisors that may be required to
Yes.
join the breakout. All right, at this time, the defendant is going to receive a $1,500 surety bond, 1,000 for count 1, 500 count 2. He is to undergo an MHET, and he must stay away from the location on River Bluff, believe it's River Bluff Parkway. He is to have no alcohol, drugs, or weapons as a condition of that surety bond.
Your Honor, I'm so sorry. Could you please repeat
I
for the
did.
interpreter? That's
Yes,
okay, don't worry.
I forgot.
Just the bonding, just the surety bond. Did you
For
say
a moment.
1,500?
Yes, for a moment I forgot this was an interpreter case.
That's
It'll
okay.
be $1,500 surety bond, 1,000 count 1, 500 count 2.
And then the MHET exam.
Yes.
Okay, thank you. Okay, y la orden del juez del día de hoy es que tiene un bono asegurado por $1,500. $1,000 por la acusación número 1, $500 por la acusación número 2. También va a sujetarse a una examinación de MHET y debe mantenerse lejos de la dirección en Riverbrook Parkway. No puede usar nada de alcohol, nada de drogas, nada de armas.
All right. Is there anything further from either the state or the defense?
No, Your Honor.
Nothing from the state.
All right. Best of luck to you, sir.
Eso es todo, señor. Buena suerte.
All right.
Your Honor, if that is everything, may I please be excused?
Yes. Enjoy the rest of your afternoon. Take care.
Thank you, Your
All right.
Honor. Bye-bye.
All right, what position do we have next?
Position 9, Russell.
All right, good afternoon, Mr. Russell. Your case number is 22 CR 005730Y, in which you're charged with 1 count of simple battery, family violence, and 1 count of cruelty to children in the 3rd degree with the offense date of August 26th. Do you understand your rights?
Yes, ma'am.
Thank you, Ms. Harrison.
25 cycles, last arrest, June of this year for probation violation in Fulton County. Underlying charge is criminal attempt to commit robbery. Record indicate the defendant is currently on probation for criminal attempt to commit robbery by intimidation, 12 SC 113714, sentenced May of 2013, 10 years probation. Additional open probation, theft by shoplifting, 22 CR 005332, sentenced August of this year, 12 months probation. Record indicates 3 violations of probation within the past 10 years. He has 2 misdemeanor battery convictions outside the 10-year period. Nothing further to add.
All right, thank you, Ms. Harrison. Ms. Francis?
Yes, Judge. Judge, this is a dispute between boyfriend and girlfriend based on the information we have. The defendant caused physical harm to the victim by pulling on her and punching her in the face, and did this in the presence of her child, knowing that the child was present. The state is recommending a surety bond of $4,000 for the simple battery and $4,000 for the cruelty to children, for a total of $8,000 surety. No further contact with the victim. Her first name is Irial, that's Erialle. Last name is Sutton, Sutton. Stay away from 514 Parkway Drive. Family Violence Intervention Program, and no drugs, weapons, or alcohol while on bond. Judge, in addition to what pre-trial outlined, I saw multiple FTAs in this defendant's cycle. The defendant is obviously a recidivist and will likely reoffend. In addition to that, Judge, you will likely not show up to court when required to do so based on this information. Hence, we're recommending the $8,000 surety bond total.
All right, thank you, Ms. Francis. Ms. Moses counts?
Yes, Your Honor. Mr. Russell is 35 years old. He does have a good address. He does reside in Atlanta. Your Honor, he is gainfully employed. He works in construction and has done so within the last 2 years. He's maintained that employment. However, based on his income, he would qualify for the services of the public defender going forward. He is born and raised here. He does have significant ties. And while I do understand the recitation of his criminal history spanning the last several years, I would ask for your consideration for as low of a bond as possible on both offenses.
All right, thank you. At this time, the defendant is going to receive a $3,000 surety bond, $2,500 count 1, $500 count 2. He is to have no further contact with the alleged victim, Ms. Sutton. He must stay away from the address on Parkway Drive. He can return one time with a member of law enforcement if necessary to get any items. And he is to have no weapons, drugs, or alcohol as a condition of that bond. All right, is there anything further from the state of the defense?
Family Violence Intervention Program, Judge, or anger management?
Well, it's a surety bond, so
Okay.
I'm not going to order that this time. All right.
Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 10, Watkins.
All right, good afternoon, Mr. Watkins. Your case number is 22 CR 005728F, in which you're charged with 1 count of battery family violence. Do you understand your rights?
Can I make a statement to Ms. Counts?
I don't think you should do that, but the best thing, let's get into your case first. Do you understand your rights? Your right to remain silent and your right to an attorney?
Yes.
All right, Ms. Harrison?
Judge, no prior history. He does meet the criteria for UJR pretrial. Nothing further.
All right, thank you. Ms. Francis?
Yes, Judge. This dispute occurred between boyfriend and girlfriend. Victim told officers that they were supposed to be staying with her father at his house. And while they were there, they got into a verbal argument that turned physical. In this case, the defendant bit the victim as she was trying to close the door to lock him out after she asked him to leave when the altercation started. The officers did observe the bite mark on her hand when they showed up. The state recommends a 3,000 surety bond in this case, a stay away from 2615 Roosevelt Highway. I'm assuming that's the father's address, Judge. We'd also like to do a stay away from the victim's home. No further contact with the victim. The name is Qudaja, that's Quadaja, last name Talley, Talley. Family Violence Intervention Program, and no drugs, alcohol, or weapons while on bond. Your Honor, even though this is the defendant's first cycle, this incident did also occur in the presence of at the parents' residence, at the victim's parents' residence, Judge. So we do believe that based on the relationship between the parties, there might be future intimidation. So for these reasons, the state is asking for the surety bond of 3,000.
Thank you. Ms. Moses counts.
Yes, Your Honor. Mr. Watkins is 26 years old. He does have a good address. He does reside in Atlanta. He is gainfully employed. He works at UPS as a warehouse associate. Your Honor, he has significant ties to the state. He's been here for 13 years. And as you heard, he has no criminal history, Your Honor, at 26 years old. And so based on that, I would ask for your consideration of a signature bond.
All right, thank you. At this time, the defendant is going to receive a $6,000 signature bond through pretrial services. He's to take the one-day anger awareness course and have no further contact with the alleged victim, last name Talley. He must stay away from the address on Roosevelt Highway. And as well, he must also stay away from the alleged victim's address. He can return one time with a member of law enforcement to get any items he may have from either stay away location. And he is to have no weapons, drugs, or alcohol as a condition. Is there anything further?
No, Your Honor. Thank you.
No, Judge.
All right. Best of luck to you, sir. That concludes your case. Please call Ms. Moses Counts if you have other questions. All right.
Thank you.
All right. Who do we have next?
Position number 2, please. Courtroom 3.
All right. We're going to go to the case of Anaya Brooks, case number 22. CR005725Y, in which the defendant is charged with 1 count of simple battery. The offense date of July the 9th of 2019. Do you understand your rights?
Yes, Your Honor.
All right, thank you. Ms. Harrison?
Your Honor, second arrest. First arrest was July of 2019 for simple battery, arrested by South Fulton PD. No disposition listed on that arrest. This defendant did appear in first appearance and was granted a $7,500 good bond. Nothing further.
Thank you, Ms. Harrison. Mr. Borger?
Thank you, Your Honor. I want to start by addressing that incident date for 2019. Because of the statute of limitations tolling order from the Supreme Court that was issued during the COVID time period, the state is within that statute of limitations by 1 year and about 11 months. So we're right on time. Your Honor, the state is asking for a $2,500 surety bond. No further contact with Shakira Williams. Stay away from 5500 Oakley Industrial Boulevard. Enrollment in the Anger Awareness Program. And no guns, drugs, and alcohol while on bond. Your Honor, in this case, Ms. Brooks had harmed Miss Williams. This is the same location that Miss Brooks was arrested for pointing an aggravated assault. She was originally charged with pointing or aiming a gun at another. Those charges were sent up as a felony. So what we're seeing right here now is Ms. Brooks is again angry and violent and owns a weapon and is disputing with people in her apartment complex. That's obviously fairly dangerous. And I think that a $2,500 surety bond is quite generous given the circumstances. Nothing further from the state.
Thank you, Mr. Borger. Ms. Melnick?
Yes, Your Honor. This incident date was on 7/9/2019. The warrant is deficient in that it states it causes physical harm to Shakira Williams by Shakira Williams. so it's deficient. Miss Brooks is 24 years old. She does not have any prior convictions. She lives with her mother, Latanya Brooks. The state is asking for her to have she qualifies and she meets the criteria for unsecured judicial release. So we are asking for a UJR on this case, given the age of it, given the alleged deficiencies in the warrant, and given her criminal history and the fact that she does qualify, we are asking for a UJR.
All right, thank you. At this time, the defendant will receive a $1,500 surety bond. She is to have no further contact with the alleged victim and must stay away from the incident location. She is to have no weapons, drugs, or alcohol as a condition of that surety bond. Is there anything further from either party?
No, Your Honor.
Nothing further.
All right, best of luck to you. Who do we have next?
Position 5, Gouda.
Kudo.
All right, good afternoon, sir. Your case is 22 CR 005723J, in which you're charged with criminal trespass with the offense date of August the 26th. Do you understand your rights?
Yes.
All right, Ms. Harrison.
Judge, third arrest. Last arrest was January of 2020 for probation violation. Underlying charge was possession of marijuana less than an ounce. That arrest was dismissed. He does meet the criteria of UJR pretrial. Nothing further to add.
All right, thank you. Mr. Borger?
Thank you, Your Honor. The bond was already set at a $500 surety. The state is just asked that we keep that bond the same, along with the conditions of a stay away from 1155 Mount Vernon Highway, and no guns, drugs, and alcohol while on bond. Your Honor, the defendant was found sleeping on the premises of Site Centers. That's the 1155 Mount Vernon Highway address. The defendant had been issued a criminal trespass warning by Sandy Springs Police 3 days prior to this current incident that we're dealing with now. Again, I know that signature bonds are popular for these criminal trespass type cases, but given that he's clearly residentially challenged, I'm not all that encouraged that he will continue to appear for court, as evidenced by the probation violations that we've seen in the past. From these cases, as this case progresses through the system, it's likely a fine would be the only type of penalty he would incur. So I think that surety would likely satisfy this whole case to begin with, and we don't have to worry about probation violations or FTAs going forward. Nothing further from the state.
All right, thank you, Mr. Borger. Ms. Melnick?
Your Honor, as evidenced by defendant's lack of criminal history, that except for the a possession of marijuana, which some cities are now decriminalizing, he was simply asleep. And as Mr. Berger said, this is a fine. However, if his state feels so strongly about the minimalization of this case, we are asking for UJR. He does qualify. He has a present address of 285 West Wayuka Road, apartment 4236, Atlanta, Georgia, 30342. And since he was asleep, and the state fully admitted it's a minor case to them, we are asking for that UJR.
All right, thank you. At this time, the defendant will receive a $2,000 signature bond through the jail. He must stay away from that incident location and have no weapons, drugs, or alcohol at this time. Is there anything further?
Nothing from the state.
All right, best of luck to you, sir. Don't go back there, okay? Who do we have next? We're muted at courtroom 2. Who's next?
I'm sorry, Judge. I didn't know I was muted. Yes, please be advised, position 6. He is Mr. Linson. He's hard of hearing, but he does not understand sign language. So if you guys talk really loud, that would
And
help.
can we put the translation on? Can he read it as well? The caption, we're gonna close caption this as well.
Okay.
All right, good afternoon, Mr. Linson. This case is being closed captioned, so you should be able to read what's happening on the screen as well. Your case is 22 CR 005724G, in which you're charged with 1 count of criminal trespass and 1 count of theft by taking, with the offense date of August the 25th of 2022. You have the right to remain silent and you have the right to an attorney. Do you understand those rights today?
I didn't see you.
Right here. Can you, yeah.
I didn't see you.
Yeah, he's reading it, Judge.
Okay. Do you understand your rights?
Yes or no?
What right, what right?
Just
You
say
have the right to remain silent and the right to an attorney.
You have the right to remain silent. Yes.
All right, thank you. Ms. Harrison?
Your Honor, 25 cycles, last arrest, February of 2016 for criminal trespass in Fulton County. That was a conviction. Record indicates a 2011 misdemeanor conviction for criminal trespass and theft by taking misdemeanor. Nothing further to add.
All right, thank you. Mr. Borger?
Thank you, Your Honor. State's asking for a $1,500 surety bond with the conditions of a stay away from 1060 Snyder Street, SNYDER Snyder Street. No further contact with Winston Shao, that's spelled XIAO, and no guns, drugs, and alcohol while on bond. Your Honor, the defendant is accused of going on to Mr. Shao's front porch and taking his bike. This was captured on front porch security camera, and Mr. Shao was able to actually recover his bike because he had one of those Apple air tags on the bike. The bike was found at what was kind of described as like a bike junkyard, I guess, where people try to fence bikes. And we see from the defendant's history, 25 cycles, burglary, criminal trespass, hit and run, theft of miscellaneous property. So I'm not too encouraged by the defendant's history. So he's got a history of theft, history of damaging property, not too much accountability in there either, the hit and run. And then we see even some violence with the simple battery, aggravated assault arrest, which was later dead docketed, in a possession of cocaine back in 2009. So maybe some drug problems as well. So I think that the surety would just encourage a little bit of accountability here. Again, the bike was recovered. So I do think a $1,500 surety bond would be appropriate.
All right, thank you. Ms. Melnick?
Yes, Your Honor. Mr. Linson is extremely hard of hearing. He's 64 years of age. He does meet the criteria for a UJR. He has not had any prior felony convictions within the past 10 years. He does not have, he does have a sister, Tara, T-E-R-A, Rochelle, R-O-C-H-E-L-L-E, Bell, who lives in the Atlanta area, and he can stay with her if he's released. He is indigent. He does not have any money. The state is asking for a UJR as recommended by this pretrial report. And the alternative, we're asking for a $500 signature bond on each count for a total of $1,000 signature bond. Again, he is indigent, and as any type of surety bond is the equivalent of no bond for him.
All right, at this time, defendant is going to receive a $2,000 signature bond to the jail, $1,000 each count. He must stay away from the address on Snyder Street and have no further contact with the alleged victim, last name Sal. He is to have no weapons, drugs, or alcohol as a condition. Is there anything further from either party?
Nothing from the state.
No, Your Honor, thank you.
All right, best of luck to you, Mr. Linson. That concludes your case.
Oh,
Yep. You can go. Have a seat right here for me.
You gonna let me go home?
Yes, you want to go?
Thank you.
All right, you're welcome. All right, last case, Judge, is position 8, waive their appearance.
Okay. Ms. Melnick, you did a formal waiver of the appearance? Is Ms. Melnick still here, or is it Ms. Moses Counts?
I think it's Miss Combs.
Yes.
Ms. Counts?
Your Honor, I was just asked by the jail if I would speak to him, and he agreed. He just verbally and told me he didn't want to come to court, but he wanted me to represent him today.
Can you still submit the waiver to Mr. Jordan so that we have proof? You can sign on his behalf, all right?
Yes, do you know where I would get the waiver? Is that just something I should draft?
You just type it up, yes. That's
Okay.
what they've done. You can be excused at courtroom 2. Have a great rest of your afternoon. Take
Thank
care.
you. You too.
All
Thank
right.
you, Judge.
All right, bye-bye. All right, we're, this is the case, 22 CR 005732Y, in which defendant Weston Rose is charged with an offense I will not sound, with the offense date of August the 26th. Ms. Harrison, can I have his history, please?
39 cycles with history in Georgia, Minnesota, Missouri, and Indiana. Last arrest is June of this year, entering auto in DeKalb County. No disposition listed on that arrest. Record does indicate 1 failure to appear within the past 10 years. He has a 2022 criminal trespass out of DeKalb and a 2017 misdemeanor theft by taking and criminal trespass out of DeKalb. He also has some additional judge in his GCIC. It's indicated that he may have some MH issues.
Okay.
He's not recommended for pretrial, but pretrial will take him with wraparound service if you decide, Judge. So he has arrest history out of Minnesota. One is a CWAC charge, but it's a misdemeanor. And so he is required to register until 2030. And he has he has 4 criminal trespass misdemeanor convictions, nothing further.
All right, thank you. Ms. Francis?
Yes, Judge. Judge, are you aware of the facts, Judge?
I'm not. Can we go into a breakout, Mr. Jordan, please, very briefly? All right, at this time, the defendant is going to receive a $2,000 surety bond. He is to stay away from the East Point MARTA station at 2848 Main Street. He is to have no alcohol, drugs, or weapons, and he is to undergo evaluations as discussed in breakout. Mr. Jordan, I will chat them to you. All right, is there anything further from either the state or the defense as it pertains to that case?
No, Your Honor. Thank
All
you.
right, all right, hearing none, I believe that concludes our entire calendar. Mr. Jordan, will you review it for me? Or Ms. Francis, outstanding issues?
Judge, I had 2 cases that I think were added after. I'm not sure if you have them.
I didn't receive an add-on calendar.
Your
These are
Honor, I
bind
still-
over cases.
I'm sorry, I
Yeah.
also they didn't reach one of my clients, Mr. Robinson. Lawrence.
Mr.
Those-
Robinson, the felony case.
No.
Okay, I didn't know that. It was upgraded.
No, it was actually a felony arrest charge. He had a 22 CP case number, but he was on the misdemeanor pull sheet. And the only other case he has is a bench warrant arrest from a 04 case.
Okay, thank you for clarifying, sir. Thank you.
I'm sorry, what were the other cases, Ms. Francis? Because I have it, the calendar is complete.
Okay, Judge, that's fine with me. I had Harris and Wallace, but
Those are bind overs. They just go straight to state all-purpose calendar.
oh, okay. Thanks. Great.
All right. All right, can we review the calendar?
Yes, Judge.
Position 1 is a $1,500 surety bond. 1,000 for count 1, 500 for count 2. Reset SAP. Position 2 is a $1,500 surety. Reset SAP. Position 3 is a $3,500 surety. Reset SAP. Position 4 is a $500 surety. Reset SAP. Position 5 is a $2,000 sign-on bond jail. Reset further notice. Position 6 is a $2,000 sign-on bond jail, $1,000 per charge. Position 7 is a $4,000 sign-on bond pretrial. Position 8 is a $2,000 surety. Reset SAP. Did you want that on the competency calendar as well?
Yes, if possible, and reset to the, is that reset date a Thursday? Or is that
It is a
reset
Thursday,
date?
Judge.
Okay,
It'll be
yeah,
on
so
that same date.
yeah, on that same day, just the competency calendar.
Position 9 is a $3,000 surety, 2,500 for count 1 and 500 for count 2. Reset SAP. Position 10 is a $6,000 sign-on bond pretrial.
Jail,
Reset
right?
further notice. And position 11 is
Wait,
a
I'm sorry,
5,000.
10 was jail, right?
Oh, was it jail?
No, position 10 should be through pretrial.
Oh, okay. And position 11, I have a $5,000 sign-on bond pretrial, 2,500 per charge. And that's it.
Any comments, changes, corrections, or questions?
Nothing from me.
All right, hearing none, we'll be in recess until the SEA calendar on Monday, at which time I believe Judge Morrow is presiding. Take care, everyone.